My name is Lior Strahilevitz, and I'm the Deputy Dean and Sidley Austin Professor of Law at the University of Chicago Law School. I teach courses here on privacy law and property law, so it's really exciting to see a case that involves both of those loves of mine at once. The Supreme Court's oral argument in the Jones case was one of the more lively and interesting oral arguments that you'll see this term. In the Jones case, the U.S. Supreme Court has to consider whether the police's installation of a GPS device on a suspect's car and the subsequent use of that GPS device to monitor his movements over the course of several weeks constitutes either a search or a seizure under the Fourth Amendment. The law enforcement obtained a warrant before they installed a GPS device on this particular suspect's car, but they then exceeded the terms of the warrant, monitoring for too long, and therefore it's as if, as a matter of law, there was never any warrant issued to begin with. So the justices, and you can hear them struggling with this during oral argument, are trying to figure out what the proper legal framework is for discussing this issue of new technology. Should it be the courts, via an interpretation of the Fourth Amendment, that decides whether the use of GPS without a warrant is permissible, or should Congress step in, or maybe even the state legislatures? That's one of the things that the justices kept coming back to. My own view of the case is that there will be a new legal rule emerging from Jones, which is that before the police can install a GPS device on a suspect's car, they'll need either the owner's consent or a warrant. The reason I think that's what's likely to happen is you essentially saw two camps on the court that seemed very concerned about what law enforcement had done. On the one hand, justices like Sotomayor seemed very concerned about the extent to which this sort of pervasive 24-hour monitoring, not only of criminal suspects, but potentially of anyone, could create a sort of 1984 scenario where the government is monitoring everyone and doing so with no judicial checks. On the other hand, Justice Scalia seemed quite concerned about the extent to which the government's installation of a GPS device on a suspect's car without his consent violated the suspect's property rights and therefore ran contrary to the original understanding of the Fourth Amendment. To Justice Scalia, it seemed likely that the installation of a GPS device on a car amounted to a trespass, and going back to the very early understanding of the Fourth Amendment was understood to prevent law enforcement from, let's say, breaking into someone's house to search for evidence or interfering with their personal property without some sort of a warrant. So you heard Justice Scalia questioning the government's lawyer quite aggressively and saying, look, how can it be that the Fourth Amendment means less today than it meant at the time of the founding? And what I think might ultimately happen is that you won't have one opinion on behalf of 5 justices, but you will have 5 justices agree under varying rationales that that what the government did was improper, and that going forward the installation and use of a GPS device is something that's going to require a warrant. So the other aspect of oral argument that was very interesting and that a lot of people may not have noticed because it came at the end of a very heated oral argument was Justice Kennedy's questioning of counsel along the lines of the following. Justice Kennedy asked whether it would be a tort, whether it be civilly, whether it would lead to civil liability if one neighbor stuck a GPS device on another neighbor's car. Now, counsel for the government gave a pretty unsatisfying response to that question. He said, essentially, it may well be a tort under state law for one neighbor to monitor another neighbor's movements via the surreptitious installation of a GPS device. But he said that didn't matter because other cases had indicated that the Fourth Amendment and state tort law could mean different things. I think Justice Kennedy might ultimately have some interest in re-examining that language from some earlier Supreme Court opinions And I think what he's potentially interested in doing is trying to create greater coherence within privacy law more generally, saying that when the Fourth Amendment asks the justices to consider whether there's a reasonable expectation of privacy against the use of GPS monitoring surreptitiously, that maybe when a state court in a tort case has considered whether there's a reasonable expectation of privacy that one neighbor may have against a stranger's installation of GPS, that those two questions are related somehow. I'm quite sympathetic to that approach, and indeed have written an article called Reunifying Privacy Law that tries to explore this question that Justice Kennedy was so interested in. How can it be that a reasonable expectation of privacy means one thing in the Fourth Amendment context and something entirely different in the privacy tort context? There's simply not a good answer for that question, and to simply say, because a court earlier said so, that's not necessarily something that the Supreme Court, which obviously gets to revisit any precedent already on the books, is going to view as a satisfying answer. And so it'll be interesting to see whether Justice Kennedy writes separately to advocate on behalf of creating greater coherence in privacy law, and whether any of the other justices go with him if he does go that route.
I think the court should hold that this is a search under the Fourth Amendment, after which they can then adopt any number of rules to regulate when the search can occur. Holding that as a search doesn't mean that it's unconstitutional. It just means that it then has to be a reasonable search. And I agree that it requires some adjustment or narrowing of the prior case of United States v. Knotts. But the court has done this, does this from time to time in important cases. And in fact, one of the important Supreme Court cases on the Fourth Amendment, a case called United States v. Katz, is exactly a major adjustment of this sort. That was the case where the court first held that wiretapping on a public phone, at a phone booth, was a search. And the problem the court faced there was it had previously had this idea that a search involved a trespass on someone's property. So only when the government trespassed on your property were they searching you under the Fourth Amendment. And in this case, because it was a public phone, listening in on it when the person was in the phone booth was not a trespass. So the court abandoned that prior understanding of a search. And I think it's a good idea at this point to abandon the reasoning in Knotts that said that people have no expectation of privacy in their public movements, given that a lot of the secrets people have are revealed to one who can track all of their public movements over a long period of time. I think that people do expect privacy in their public movements. And it wasn't that important, as I explained, it wasn't that important in Knotts because to say it was a search, because it still was pretty expensive for the police to use a beeper and track people with this earlier technology. But now that it's becoming extremely less and less expensive for the police to do it, it becomes a real concern that they might search people, or I should say follow people, track their public movements without adequate reason. So I think it's a good opportunity for the court to get involved before it really is too late. If at this point the court says again that there's no expectation of privacy in public movements, then I think there really is no opportunity down the road, or at least it would be even more difficult down the road to later say, when the government is using satellite technology or something else to track public movements of all of its citizens all the time, that somehow that's different from the kind of case that we have now.
I'm not going to make any prediction on what the Supreme Court is going to do, other than I hope that they make the right and what I think ought to be a fundamental and easy call, which is simply this. It's that if the government wishes to place some kind of monitoring device on someone's car to monitor their every movement, even in public spaces, that simply they need to first go see a judge and ask for a warrant. There's no emergency in this case. No emergency is alleged. And there's always are exceptions to warrant requirements when there really are true exigent circumstances or an emergency. And it seems that there are very little, if any, costs to, if you want to engage in some monitoring or spying like this, similar to if you wanted to put a wiretap on someone's phone. It's not simply you can't and can't do that, but you need to have one probable cause to believe that person is engaged in a criminal activity, and then is the kind of search or seizure that you're seeking to do reasonable, and that's what the Fourth Amendment's about, and that there's a check. Is this a reasonable way? So if you have probable cause to believe that a person is engaged in criminal behavior, just like warrants can be overbroad, is this order or is this search or is an order allowing putting a GPS device for a certain number of days on a person's car to monitor their movements, tailored to that particular probable cause, and to have something in between just law enforcement, we can do this whenever we want, with or without cause, or even if we think we have probable cause, that there's a check and a necessary check on government, that go to a judge, seek permission, show that there's cause for this. And if there is cause for this, it can be appropriate. And I think that's basically the position of Mr. Jones, Antoine Jones, and his lawyers who are defending this case, that it was illegal to do this without, it violated the Fourth Amendment to track his every movement by surreptitiously placing that GPS device on his car, without first any probable cause to believe that he'd done something wrong, and secondly, not just probable cause, but there was no urgent or immediate need to do this without first seeking a warrant and going to a judge first to say, is this okay?